Okay, have a seat. All right. Okay, thank you. Our third case on the docket, the last one today, is 18-2729. Sean Hengesbach as personal representative of the estate of Dorothy Gianelli versus Florida Insurance Guarantee Association.
Good morning, Your Honors. May it please the Court Counsel. My name is Michael Lorado. I represent the appellant in this case, the state of...
You want 5 minutes rebuttal?
I'd like to reserve 5 minutes for rebuttal, please.
Very well. Okay.
We're seeking reversal of an order of the lower court denying attorney's fees in this insurance action because not to permit attorney's fees in our position would render the statutes unconstitutional, which the fees were denied under. I'd like to begin my presentation by acknowledging that for over 100 years in this state, we've recognized for strong policy reasons that any time an insured brings a case against an insurance company, that there's been a right and entitlement to fees, and there's strong policy reasons behind that. For even as long, our jurisprudence has recognized the right of counsel for other important policy reasons, namely access to courts and due process, to contract with attorneys in certain types of cases, including insurance cases, on a contingency fee basis. Those contracts have been permitted and allowed in the law, and they've been approved by the Florida Supreme Court.
And your contract was a contingent fee, correct?
It is what's known as an alternative contingency fee contract, which
the court awards or?
Court-awarded fee or a percentage of the entire award, whichever is greater, but not both. That specific contract's been approved by the Florida Supreme Court in a case called McDonald, that type of fee agreement, for use in these particular types of insurance disputes. With that background in mind, we turn to the particular statutes at issue in this case, and this insurance case implicated FIGA. So the FIGA statute was implicated, the Florida Insurance Guarantee Association.
You would agree FIGA is somewhat, it was a statutory scheme, obviously, but it's kind of a little bit different than your own insurance company, correct?
I would agree in principle with that position, but for purposes of interpretation of the FIGA statute and interpretation of FIGA's role when an insurer becomes insolvent, the FIGA statute is clear. FIGA is deemed the insurer to the extent of the policy.
Right.
More than that, and FIGA presents arguments in its brief and in its brief that it somehow is different. This circumstance involving attorney's fees isn't the first time that this court has interpreted FIGA statute and held that it applies equally to FIGA as it does to any other insurer. For example, in a prior case of this course, and there's a written opinion on it, it was between Ms. DeFori and I, we represented the parties in that case. What the issue in that case was this statute, in addition to altering the attorney fee provisions, also altered the statute of limitations. And so FIGA's position, and they were ultimately successful in that case in having the case dismissed on statute of limitations grounds, asserting that the statute of limitations in this particular FIGA statute created a different standard. And this court reversed on that opinion. And that case is cited in our brief. So the notion here, the important point is that every time that FIGA has kind of asserted that it's a different animal, it's different than an insurance company, in fact, that's contradicted by the FIGA statute. And every time the courts have applied the FIGA statute to that particular argument, they've rejected it because the statute itself deems FIGA the insurer that went insolvent. Turning to this statutory background.
Let me ask you this. You agree that, I guess, in this particular case with your contract, because you settled it the way it was settled, there would never be any fund, there wouldn't be a fund to get your contingent fee, correct?
That's correct. That's the impairment of contract argument.
We're not talking about, that's your impairment of contract act.
The impairment of contract argument is the last argument raised in my brief.
You entered the contract before they changed the statute?
Correct. Yeah. That is a clear-cut right.
But you settled it. I mean, you settled the case, and you specifically said in there, look, you're going to pay to the contractor. So there were, as a result of the settlement agreement, there would never be a fund to get your contingent fee.
It's important to note that the contract provided for a statutory fee or a contingency fee.
That's what I'm saying.
Right.
So we're talking about the statutory fee at this point, are we not? Probably.
Well, the only method which this statute can be saved from unconstitutionality and not impair the contract is to allow a statutory fee. That's the point of the impairment of contract argument.
Okay.
Because this particular statute, this isn't the first time that a court has addressed these attorney fee provisions either. In order to save this particular FIGA statute prior from unconstitutionality and avoid these constitutional issues, the second District Court of Appeal in the Miller case, at that point, FIGA's position was that 631.54C applied to all sinkhole cases, and it never had to pay an attorney fee in any sinkhole case, whether it was a confirmed one or a denied one. To avoid the equal protection and impairment of contract, access to courts issues, and due process issues, the Second District Court of Appeals said that we can save this statute. We have to read it in peri materia with 631.70. And they required FIGA to pay 627.428 fees on a sinkhole case, even though 631.54C says they never pay attorney's fees. That raised the issues, the Miller case raises the issues we have here. Underlying both of these statutes, we know they have to be read in peri materia. So there has been a dichotomy, a classification for equal protection purposes. The first, by Miller's reading and the reading of these statutes in peri materia, is a dichotomy between denied sinkhole claims and confirmed sinkhole claims. That classification has to be in denied cases, denied sinkhole claims, they get attorney's fees. In confirmed cases, no attorney's fees. And since FIGA can't pay it directly, there's no fund either.
Okay.
So it's only in confirmed cases where an entire class of insureds have no access to counsel and therefore no access to the court because they cannot contract on a contingency fee basis because there is no fund and there is no statutory fee. That's prong one. The second classification is between sinkhole cases and all other insurance cases. Hurricane, water, fire. In those cases too, FIGA does not pay a statutory fee unless they deny the case.
Deny coverage.
Right?
Or deny.
Unless they deny coverage.
Basically, yeah.
Okay? If they deny coverage, you can get fees in those.
Right.
But in those cases, in a hurricane, in a fire, in a water loss, in a burglary, in a in any other insurance context, there is not the prohibition of no direct payment.
Right, correct.
And so the second unlawful equal protection
I
classification,
guess there was some basis that they did that. I guess people weren't fixing the house. Is that what the issue was? And then the
That's,
houses just sat there?
that is correct.
Yeah.
And we concede that that is a legitimate governmental interest.
Yeah.
But the method in which the statute accomplishes that is unlawful. You don't accomplish that governmental interest of ensuring that homes are repaired. And in fact, even in denied cases, there is that repair mandate, right? So whether your case is confirmed or denied, if you win your denied case, you're going to repair the home.
fund. I mean, the
Right.
fund, yeah.
Right. But you get statutory fees. The way to ensure that homes are repaired, the way to further the legitimate governmental interest is not to cut off an entire class of folks from representation. That leads us to the due process argument and the access to courts argument. This has also been addressed by the Florida Supreme Court in a similar circumstance. In Warfel versus Universal, the sinkhole statute, which governs this insurance dispute as well, set up what was known as a presumption of correctness. There, that statute said that the insurer's expert report is presumed correct. The insurance companies then, including FIGA, took the position that we've got our expert, we can rely on it. There's no way that you can contest that in a confirmed sinkhole case. You have to accept it. The Florida Supreme Court and the Second District Court of Appeal rejected that, said that even in a confirmed case, there are due process rights to contest that expert testimony. It's simply a rebuttable presumption, and to interpret the statute to create an irrebuttable presumption is a violation of due process, would be to do so unconstitutionally. The effect of these statutes is clear. FIGA doesn't pay attorney's fees. There's no way in a confirmed case that any attorney can ever get paid. So FIGA comes in and says, and it encourages, it's actually an encouragement of the underpayment of claims. They come in, they confirm the case, hire their expert. How is that legally disputed? That's legally disputed in court by hiring an expert, hiring an attorney, and contesting it. Like in this case, that's the reason the settlement was important, because the settlement was for more than what FIGA settled the case for. Traditionally, our law recognizes, long history of jurisprudence in this, that where an insurer settles a case for more than what they offered, that's also an entitlement to attorney's fees for access to the courts, due process, and those other issues. But what FIGA statutes do here, by essentially cutting off access to any lawyer to reasonably take the case, what happens is they create not a de jure, not the presumption of correctness, which Warfel said would be unconstitutional if they wrote it in the statute. They create a de facto presumption of correctness, because there is realistically no way that any insured can ever reasonably contest FIGA's assessment of a confirmed sinkhole case without, and as FIGA concedes, hiring a lawyer out of their pocket, which very well may be the may be the correct.
The thing about it is, in my view, I mean, there are a lot of different kind of cases where you don't get fees. I mean, fees are generally statutory by rule or contract. I mean, when you're right down to it, sometimes case law too, but, you know, I mean, that's basically it. So you got all kinds of different causes of action that require somebody to hire a lawyer to come in. Without the hope of some fund to get a contingent fee or some method for getting attorney fees paid.
I think that's a very important point in this case, and we have to take the historical context, which has been accepted in this in our state. It has been the law in this state that an insurer in an insurance context,
627-428.
more than a century. Personal injury.
Not every state has that.
Representation on a contingency fee in an insurance matters has been one which is accepted. It has been judicially determined as the poor man's key to the courthouse.
North Carolina has it, but it's for claims under $5,000. You know, it's that kind of thing. I mean, every state has a different way of doing it. You're right.
The question becomes here is, what's the purpose of this statute? What's the reasonable basis for it? What's its legitimate governmental interest? We agree that repair should be done.
It probably has.
It was done in this case.
I would
But
guess.
it was done, the proper repair. The important thing is not that the home's repaired, that it's properly repaired. There are systemic issues involved in this case. How does a civilized society adjudicate
Let me
a
ask
bona
you,
fide
I'm not sure how FIGA gets funded. I guess from the insurance companies fund it somehow.
All of us do.
Huh?
All of us do.
They
On every insurance policy, there's a
gets paid into that.
premium,
I
and
don't know
and they are not a public entity.
No. Does the general fund pay anything into it, I wonder? I mean, I don't know. But I mean, I think the real issue is that. It's financial. In other words, an insured, gets a policy with the Holy Grail Insurance Company and is paying a real low premium until there's a claim, and then the company goes bust, and then FIGA's got to take it. I can see kind of the public purpose of maybe not having it exactly the same as 627, 428.
But the FIGA statutes incorporate these arguments. They acknowledge them as they must. They must conform to the Constitution.
Well, I
FIGA,
agree with
the
that,
entire
too.
purpose of FIGA is to protect the insured, not the insurance industry. Here we have an insured who has already suffered a loss and then has suffered the second loss of the insolvency of their insurance company, and then FIGA is deemed to be their insurer.
They're probably in a lot better position than they would have been if there was no FIGA, correct?
No question about that.
question about
there's,
that.
there's no question about that. But that in no way authorizes the legislation here which defeats substantive due process, which our courts have said that these disputes, these precise disputes, are decided by juries, and one side doesn't get to unilaterally decide.
So
And
you're into your rebuttal time. You can go forward or you can stop, whatever.
I'll make one more comment, and then I will sit down. I think importantly, the legislative history of the statute, and FIGA will concede that the entire purpose of this statute was not to effectuate repairs. It was to discourage people from bringing these type of claims because it viewed it as a litigation crisis, in the same respect that the PIP suits, the medical malpractice were all considered as litigation crises. And I would note that every single time the legislature has attempted to intervene and impose restrictions on hiring lawyers and access to courts, the courts have ruled that it's unconstitutional. That's not the way we do that. And so in the workers' compensation realm, in the PIP realm, in even cases in sovereign immunity, medical malpractice, every time there has attempted to be a cutoff to the lawyer or the methods in which people traditionally gain access to the courts through legislation such as this, it's been ruled unconstitutional, and there's no...
The purpose of the statute is in the statute.
And namely, the purpose of the statute, as said in the statute, is to help insureds, not the insurance industry. Section 631.54C was specifically legislated to deal with this sinkhole crisis, which was viewed. So how does 631.54C further the sinkhole crisis other than by denying access to the courts and denying substantive due process? So I'll reserve the remainder of my time for rebuttal. Thank you all.
All right, thank you.
Thank you.
May it please the court, Dorothy Fiore here for the Florida Insurance Guarantee Association. So we've talked a little bit about, earlier today, we've talked a little bit about FIGA, and I'd like to bring the court's attention to some lengthy discussions in my brief regarding FIGA. FIGA was created in 1970 in order to address the fact that when an insurance company became insolvent, the insureds generally were left with nothing but whatever they could get out of essentially the receivership position, which, as we all know, is like a bankruptcy, and you get pennies on the dollar.
How is it funded? Is it funded by, we all pay premiums to all the big, whoever, but they pay in, do they? Is that how it works?
So yes, so member insurance companies, and not every company in Florida is a member, but your majority of your personal lines,
Yeah.
Insurance companies, commercial policies, that's
Does
what
any general fund money go into it?
Absolutely not.
That's what I thought,
This is a created by statute. The legislature said, we're going to create an organization. It is not a governmental organization. It's a corporation. It's a not-for-profit corporation. We're going to create this corporation in order to provide this safety net, and we're going to fund it through the assessments on our members, and the members are insurance companies. Now, of course, insurance companies, while they cover a lot, they generally pass costs on, and if you ever look at your auto policy and at your homeowner's policy, if you have a commercial general liability policy, you will see, in addition to your premium, there are fees, and one of them will be a FIGA fee. The FIGA fee goes up and down depending on the amount of claims that are coming into the FIGA services. So if a whole bunch of insurance companies go insolvent, then the FIGA fee is higher.
But what do you think, what is the purpose of, 631.54.3C?
So if, so it is, 631.54.3C was designed to address the insurance sinkhole crisis. It was a sinkhole insurance crisis. Let's be clear about that.
That would be, people were making claims for sinkholes that were showing up, correct?
Right. So what happened was the property appraisers, in addition to the insurance companies, wrote letters to the legislature saying you must do something because the property appraisers were facing a crisis, primarily in Hernando, Pasco,
That would be
the
the
Sinkhole
house
Alley
didn't get
counties.
repaired, is that
and
it?
and the houses weren't being repaired
they're
because of the incentive to take the insurance money and run. I think I have a sinkhole. Well, it's too expensive to litigate because if we find out there's a sinkhole, then I'm going to owe fees, I'm going to owe testing, I'm going to owe repair fees. So we're just going to pay you a cash settlement. They would take the money, they would abandon the house, it would remain unrepaired, and the property value would then plummet. And the Hernando County, I think it was, property appraiser documented that they had lost $179 million in property values over the course of a few years. And so they went to the legislature and they begged the legislature to please provide some help. And the data call shows that the insurance companies were facing a similar crisis because the cost of remediating and repairing and dealing with the sinkholes themselves was far outstripping their premiums because every time they encountered a sinkhole claim, there was not just the hundreds of $1,000s to remediate that, there was the expense of attorney's fees because of the 627-428 penalty statute, whereby if you get any increased amount, you get all your fees. So they wanted to specifically address that. Now, for insurance companies, the legislature did not make any change. They are not like creatures of statute, and the provisions of the statute do not control what an insurance company pays. Insurance companies enter into contracts. They have premiums that they can adjust with underwriting and with properly evaluating their risks. However, the legislature created FIGA, and what the legislature gives, the legislature can take away. That's not my words. That is the words of almost every court in this state that's addressed FIGA's obligations.
It's a statutory scheme. It would make
It's a
sense.
statutory scheme. The legislature created it. The legislature can limit it, and the legislature can change it. And they said, we're going to require better testing. We're going to require better proof that there's sinkholes. We're going to require evidence of structural damage. We're going to do all these things, and then they mandated repairs so that even the insurance companies, if you want to get your replacement cost value, you have to enter into a contract and have the repairs done. And then for FIGA, because that was their creature, that was their creation, they said, we're going to make a change here. And we're going to say that a sinkhole claim, it's not a covered claim, except for these very limited parameters. And they said not just a repair mandate, but that in order to ensure that the house is fully repaired, we're going to say FIGA can only pay the contractor, the contractor who does it. So there is no cash settlement from FIGA in any respect if it's a sinkhole claim. And so that they argued that that was an impairment of their insurance policy, and I say they being the plaintiffs and the people with sinkholes. And that went up to the Florida Supreme Court, and in the De La Fuente case, the Florida Supreme Court said the repair mandate, the very provision of the statute that removes the cash fund, is a valid exercise of legislative parameter, and that is enforceable, and it's valid, and it doesn't impair the policy because nobody has rights against FIGA until the insolvency occurs. And so no contract that existed prior to the insolvency had any rights against FIGA. The policy doesn't have it, and neither does their fee agreement. And let me point out that their fee agreement was not impaired by the FIGA statute. Their fee agreement was impaired by the insolvency. They had a fee agreement by which they would collect a contingency fee from the insurance company, and it was because the insurance company went into insolvency that their fee agreement was impaired. That's what impaired it. The FIGA statute did not. And let me also point out that prior to the 2011 modification of the FIGA statute, we had 63170. 631.70 was enacted in 1977 to specifically address the concerns that 627.428 would apply to FIGA and mandate a fee every time there was a payment after suit was filed. Right. So picture what happens with FIGA. They step into all the litigation that's going on with an insurance company who just went under. And they look at the case, and as I like to say, not surprisingly, insurance companies that become insolvent don't have the best claims handling practices. And especially at the end, there are some very strange things being done, payments not being made, that they even said they would pay, that type of thing. So FIGA steps into a case And by and large, especially in first-party claims, they say, wait a minute, what is this? Let's pay these claims. Let's get them settled. This is not, and they do this, they did it when Seminole Casualty went under, they had massive settlements of all the PIP suits that Seminole Casualty was litigating. They just were like, this is crazy, get it shut down. And they shut them down within the 6 months stay. They did the same with Equicap. They come in and they just shut down what they can because they're not going to defend their policy language, for example. They don't have any long-term goal about approving some kind of practice and procedure for this insurance company. They just want to do what their job is, and their job is to protect the policyholders. So when the HomeWise and the HomeWise preferred insolvencies came about, that was FIGA's approach. But before the 2011 amendment to the statute, before we had 631-54-3C, we had 631-70. And 631-70 says FIGA doesn't pay a statutory fee, that 627-428 doesn't apply unless FIGA denies a covered claim by affirmative action other than delay.
It's not
And
a
so
covered claim, yeah.
this case, according to every single thing that's been said to you, everything that's in the pleadings, everything in the record, this case was a confirmed sinkhole. Believe it or not, HomeWise, which actually at the time was First Home, they confirmed this sinkhole out of the box. In 2009, in October of 2009, SDII said, it's a sinkhole. Let's get it repaired with grout. And SDII's estimate was $114,000. They went to neutral evaluation in 2010. The neutral evaluator said, it's a sinkhole. By the way, First Home offered $114,000 for the repairs and paid over $40,000, over $41,000 in cosmetic repairs. So First Home in 2009 paid over $40,000 for the above ground repairs to the home and agreed it was a sinkhole and said, we will pay for the grouting. The neutral evaluation came through and said, well, I think it's only grouting, but it's a little bit more money than what SDII said, and said it's $123,000 to grout the house. FIGA stepped in February of 2012 and said, it's a sinkhole. We'll pay you $123,000 in repairs. Let's get repair contracts. And instead, the argument in all of the sinkhole cases, and it's not just this one, they wanted to say this repair mandate, this amendment to the statute doesn't apply to our cases because the sinkholes occurred prior to the amendment. Yeah. But my point is, even before, let's say that the insolvency had happened in 2010, when FIGA stepped in and said, I'm going to do exactly what First Home has already offered, we've got a confirmed sinkhole we are offering to pay. At that point in time, there is no right to a statutory fee from FIGA, period. So they're asking you to invalidate a statute that had no change whatsoever on the right to a statutory fee in this case. There was never, with or without that amendment in 2011, there was never a right to a statutory fee. So then they have to argue, well, it's the impairment of the contingency percentage of recovery. And the problem with that is that the Florida Supreme Court has already expressly said the repair mandate is a valid exercise of legislative prerogative. And so they're asking you to basically disagree with the Florida Supreme Court.
Really?
Yes. And in doing that, they've made some arguments about equal protection, and they've made some arguments about access to court and due process. And the arguments are interesting. I think they've been waived. As you pointed out, there's a settlement here. And under the settlement, they agreed to take the $123,000 that was going to be used for repairs, which had it been with an insurance company, might have been a check to the attorney from which they would then pay the contractor. But instead, here, the check went to the repair contractors. The $123,000 is gone now because they chose to enter into a settlement agreement and have the house fully repaired. I laud them for doing that. I give Mr. Lorado credit for putting his client ahead of himself. But at the end of the day, the $123,000 is gone. The repairs have been made. The statutory repair mandate has been fully implemented. And now they're coming in and asking you to eliminate exactly what they benefited from. And they've spent all the money. So I'm not quite sure how you're going to undo this. How do you unring this bell? There's been a waiver. So I don't remember if it was, we had a very similar case in May in Law Week in the Pierre opinion, and we had it in front of Justice Berger. Were you there, Justice Judge Starr? Okay.
That
So,
was in this case, right?
and it
This
was very
court.
similar to this case, and the
opinion
panel issued a per curiam
a
affirmed
per curiam,
opinion in that. And in Pierre, they had actually gone to trial, and in this case, they'd actually settled. So that was the primary difference between Pierre and this case. The arguments that were raised in the brief relate to a couple of different grounds, and then today they seem to have focused pretty much exclusively on equal protection and due process. The discussions about the Florida workers' compensation scheme, the case law that's cited in that regard, we believe it's inapposite to FIGA. There's a couple very significant differences between the workers' compensation scheme and the FIGA scheme. So workers' comp was created as an alternative to the traditional tort, and so there is a quid pro quo access to court issue that you
There's an
have to
access
recognize.
issue on that one.
And we don't have that issue.
Right.
I just discussed Justice Perriente's discussion about why fees in its workers' compensation are considered to be so important and an integral part of the scheme. By virtue of 63170, it's very clear that the legislature does not consider attorney's fees.
I think it was pretty clear that in workers' comp case anyway, what they were trying to do is make it so a claimant couldn't get an attorney. I mean,
Well, and in
which
the face of a...
certainly would help, how it all worked out, so.
Right, so let me also point out that when the fees are a percentage of recovery, the policyholder is paying those fees. The policyholder's money was the $123,000.
Correct.
And
You're
if they
right.
were to have to pay 40% of that to the attorney,
Created a fund. is what
it is payment to the lawyer. That is money out of pocket for the client. As I explained in my brief, what the legislature said is we're going to take the shift, we're going to shift the risk of who doesn't get paid from the contractor to the attorney. Because if they take 40% of the $123,000,
It's not going to get fixed.
then they're not going to get fixed. That's exactly right. And so they said, we're just
do
going to
it
shift that.
themselves.
And, the legislature laid out in great detail in a data call and in reports and in letters from the reason why they felt this was necessary. We cited a lot of that to the court. It's really exciting reading if you're having an insomnia problem. And they really went at length to explain why it wasn't just a litigation issue and it wasn't just an attempt to keep people from suing. It really was designed to make sure the homes get repaired. The only time that there is an issue with the attorney's fee is when it's FIGA. So the insurance companies are still continuing to have repairs and there is still attorney's fees being paid there. But when the legislatively created organization has a limited fund, they're going to do what they need to protect that fund. And I'm not making this up. That's direct quotes out of the case law. The Williams case talks about how all of the risks are not foisted off onto FIGA. It's a limited fund, and they have the right to protect it. They are a creature of statute, and they are different. And to argue that they have to be treated exactly like insurance companies is directly contrary to an extensive number of cases, including cases in which they are denied attorney's fees. So had this been a hurricane claim and FIGA accepted it as a covered hurricane claim and the method of repairing the house had been a dispute, because I'll give you an example, they love to say you can pick up your Formica countertop, take it off, fix the cabinets, and put it back on. They did this to me in my recent water claim, not FIGA, insurance companies. And you're like, no, I don't think you can do that. I think I need to have a completely new countertop. Method of repair, substance of repair, the cost of repairing. We think you can repatch your shingles instead of getting a whole new roof, right? Had this been a hurricane claim, and FIGA stepped into it and said, we're going to offer you $123,000 to fix your house, and they settled for $123,000 to fix the house, there would never have been an entitlement to attorney's fees, whether this was in 2007, 2009, 2011, 2017, 2019. If FIGA steps in and says, it's a covered claim, and we want to pay you this, but you want more, there's no entitlement to a statutory fee. And then the only thing that changed was that when it's a sinkhole, the legislature said, well, we want those homes repaired. We want that tax base restored. We want those communities to have homes that are lovely and repaired and safe and not abandoned and not causing problems for the public in Florida. The only person who benefits from giving the contingency recovery fund is the attorney. The policyholder has gotten a fully repaired home, and under the FIGA statute, they will always get a fully repaired home. And that protects the citizens of Florida, it protects the policyholders, and it protects the tax base, it protects the insurance fund that FIGA has to deal with. One last point that I had to make, which just went out of my head. Oh,
That's it?
I guess it's gone now. Sorry. Is there any other questions?
No, thank you.
Okay, thank you, Counsel.
Thank you very much, Your Honors.
Okay, Counsel, you have 3 minutes in rebuttal, sir.
There's much Ms. DeFori and I agree on, I will say. But whether FIGA is a public entity or quasi-public entity has no relevance and doesn't matter one difference. FIGA is no different than Citizen is or any other insurance company. And Ms. DeFiori's point that I do agree with her too, that before 63154C was enacted, there would have been no statutory fee in this case, but the important point is there would have been a contingency fee available. And the idea that attorneys don't enter into settlements with ideas that of how much their clients will net out and whether those will be sufficient for repairs is also misplaced in this particular case, because there is a statute, regardless of the repair mandate that FIGA has. There is a statute which predated the De La Fuente case that requires a contract to be entered into by the insured. So before any insurance company, even FIGA, pays $1 on any sinkhole case, there has to be a legally binding contract. And yet, clients can still get attorneys under contingency fee contracts in all those other cases, but for not FIGA's repair mandate, but the specific language in 63154C, which was added. FIGA may not pay for attorney's fees. Historically, that began as them saying, we don't pay any attorney's fees in any single case, confirmed or denied. They lost that to save the statute constitutionally. The tension in this case, which needs to be decided, and I would urge this court to write on it, there has been another trial court in the 2nd District which has found this provision violates equal protection. And that's not to this point yet. But I would urge this court to write on it because the public policy tensions here are important. There are an entire class of people that are left with no real access to the courts. And the question is what is it better to do here? There is a repair mandate anyways. The homes are going to get fixed in all kinds of cases. Do you accomplish that goal by stopping people from hiring lawyers? The answer to that question, I believe, is simple. No, because our courts have held that access to counsel and the right to hire a lawyer on commercially reasonable, acceptable methods, which a contingency fee is a fundamental right. So the only way that this statute can succeed is if you do so at the benefit of another fundamental right. And I would suggest there's other ways to do that, which are already in place. If settling cases is important, there's a neutral evaluation statute, which was done in this case. It's non-binding. If repairing is the legitimate government interest, there's a statute in place for that. All of that is already done, and those interests are furthered, but they are not furthered by denying access to the courts and violating someone's right to contest matters in substantive due process. Okay. Thank you very much.
All right, counsel, thank you very much. Okay, thank you. We're done for the morning. We will stand adjourned.